Good afternoon, everyone. It is Saturday, May 4th, 2024. May the 4th be with you, hence my Star Wars garb. Sorry, little nerdy moment. And you might be wondering why I am not in color today, why I'm in black and white. So it's as I always try to keep things a little interesting and change them up. Part of it would be just simply because of the fact that it's a cloudy, rainy, dreary day here in boring old Maryland. State that I grew up in, born in, and love, but definitely not one of the great days to be outdoors, even in May. But also a little bit thematic here, which you'll come to understand in a minute, because the topic today, while a very important and uh, very relevant topic that comes up often, it's also a pretty black and white one, so hence forgive the pun, why we're trying something a little different. Although when I do my screen share, everything will be in its normal color, or at least as much color as there. But for those of you who enjoyed the last video and enjoyed the fact that it was clearly my shortest one to date, sorry to inform you, this one won't be quite as short, although it certainly won't be one of my longest ones either. But there is some really important information I'm going to be going over with all of you on this one. This has been coming up a lot lately. This will be the last video I put up before I do my big presentation at the NOSCAR, National Organization of Social Security Claimants Representatives conference, the national conference we have once a year. This year it's in Nashville, Tennessee. So I'll be presenting and speaking on a topic that actually combines at least a few of the different videos I've done previously. So I'll be eager to share that on my next video, how that went. It's the first time I'm ever attending this conference, let alone presenting and speaking at it. So I'm excited about it. And as I'm always excited to share this information with all of you. So without further ado, let's get into today's topic. And let me do my screen share. We're going to have a couple of screen share moments. There's going to be the slideshow like I always do, but then there's also going to be a interactive web share as well, which we'll get to. So I promise you that this was purely coincidence that I chose a background that's not only black and white, but it has what clearly look like raindrops, because when I made this PowerPoint, I did not know it would be a rainy day when I'd be presenting it. So here is today's topic. The Medical-Vocational Guidelines are what we colloquially refer to as the grid rules. And this is something that comes up very frequently in a lot of claims. A lot of my current, former, and future clients will definitely avail themselves of this potentially. So I thought it was definitely very important to discuss it in more detail. I looked back at some of my old videos and slides. I think I did briefly reference this in passing in my original video back in August, the ABCs of SSD. So, you know, there might be a tiny, tiny reference to this, but certainly not the level of detail I'm about to go into. Now, this topic is not something that comes up in every claim. There are going to be claims where it clearly does not apply, and I'll explain that as we go. But I hope you'll find this a very informative topic to understand a little bit more of a breakdown about the process. Always have to start out with the About Me slide, my webpage, my phone number, email, practice history, and just other little ditties about me as well. All right, but first, what's this? We have some breaking news. And again, this is not information that I knew when I was starting to put this PowerPoint together, but as soon as it happened, I had to share this with all of you, not only because it's a huge development in the world of Social Security disability, but also because this is going to be relevant in a very significant way to the topic we're talking about here. So let's get right into it. What is the breaking news? Past relevant work, you all might be familiar with that concept. I know I've talked about it in at least one, possibly more than one of my previous videos. There is a new rule change that's going to go into effect just next month on June 8th. So we're about a month away from it. Here's what it is. The old rule. As you all may be aware, past relevant work, which is step 4 of the 5-step sequential evaluation process, is work, substantial work that you've done in the last 15 years. So anything that you've done within that time period is fair game for them to look back on and say if it constitutes substantial work in that time period, whether or not you're capable of going back and doing it, even if you haven't done it recently, but you've still technically done it within the past 15 years. Well, guess what, folks? The new rule. Now it's only going to be any substantial work you've done in the last 5 years. And believe me, there aren't enough exclamation points for me to put here to emphasize how absolutely vital that change is. I mean, this is truly going to be one of the biggest game changers. And I will tell all of you that ever since the current commissioner, Martin O'Malley, took the office of commissioner, once he was confirmed, there have been so many great changes that have been implemented, some of which I'll probably address in future videos to whatever extent they come up. But in such a short period of time, he has effectuated such amazing changes for the agency, for those that work with the agency, including us as attorneys and you as claimants. And it's just amazing to see such great things that are happening and hopefully will continue happening to make this process smoother, easier, less stressful, and hopefully one that people will be more readily able to get approved and not have to fight like cats and dogs. So this is a great change. And when it goes into effect, it's going to be a true game changer for many people, including many existing clients of mine right now whose claims might have been more of an uphill battle, might suddenly not be facing the uphill battle they once were. And I am going to talk as we go through this video more about the impact of this rule. But just to address a few things here. So again, jobs further back in time will no longer be considered as a basis for denial. So it was conceivable, and I've had claims recently and in the past denied on the basis of somebody did a job for maybe, let's say, 6 months to a year. Sometimes you don't even have to do it that long for it to be considered substantial work if the earnings were substantial. But they did it literally at the very beginning of the 15-year look-back period. And it's a job that perhaps, let's say, it wasn't as physically demanding, wasn't as skilled, whatever. And Social Security could come in and say, well, in spite of your client's impairments and their symptoms and limitations, this is still a job that's within the 15-year past relevant window, and they can go back and do that work, which in reality, when you think about it, is kind of absurd, because certainly the further you get away from a job you've done long in the past, it's going to be harder to re-enter that field, especially if you're not doing something in the same or similar field currently and haven't been anytime soon. Take disability and impairments out of it for one thing. I mean, employers aren't as eager to hire someone that maybe has relevant experience, but it isn't recent relevant experience. They're going to see somebody else's resume and say, well, this person's been doing this for the last 5 years. This one hasn't done it in 15 almost. So yes, that's going to be huge. But more importantly, and this is where it's going to come up for today's purpose, the grids, as we call them, these grid rules or medical vocational rules or guidelines, are going to be harder to avoid for those who qualify. And when I go through the main points of this PowerPoint and video, you're going to understand exactly why that is. So let's jump right into it, shall we? And this is, in many ways, this is as black and white as it gets, even though Social Security will go out of their way to find every gray area possible. But when you understand how this breaks down and works, you'll understand how we can avail ourselves of this, both as attorneys representing clients and just the clients themselves. All right, so let's start, and let me move my window out of the way once again. The Medical Vocational Guidelines, or AKA grid rules, as we call them. And you'll understand when you see the not demonstration, but when you see the live version of it, you'll understand why we call it grid rules, because it lays out as one big grid of rows and columns. So here is the actual web address on the Social Security website that leads to the CFR, that stands for Code of Federal Regulations. So that's just basically where the rules are that explain all of this. This is all part of the section on Social Security disability. Here's the actual citation for it. So it's 20 CFR Appendix 2 to Subpart P of Part 404. I know that probably doesn't mean anything for many of you, even for us lawyers, it doesn't mean much, but you put this into a Google search, it'll bring it right up, or it'll bring this website up. So what the heck is it? Let's talk about that. Let's break it down a little bit. So these are a set of rules that essentially widen the path to disability, particularly for older individuals. Social Security recognizes that the older you are, the harder it's going to be for you to find work in a field that you've never worked in before, even if you're perfectly healthy. it's a common fact, and I know it sounds a little bit almost like age discrimination, that if you're staring at two resumes side by side, but one person you can clearly tell is younger, not because they revealed their age, which is not legal to require of a job applicant, but you can certainly see on a resume when somebody graduated college or law school or whatever versus somebody that graduated many years prior. So you'll know just by your deductive reasoning powers that person's the younger individual. And employers these days typically are going to take more of a chance on the younger individual, not only because they're likely to be more able-bodied and minded, but also because they're probably going to be able to be more productive just by virtue of being younger. They're probably going to be more hungry to be productive and prove themselves and advance in their career field. And they're probably going to cost less. That's just a simple fact. I mean, that's an economics fact, if you will. And I'm not an economist, but that certainly is the way of it. So that's just a standard fact. Well, Social Security recognized the inherent unfairness of saying, well, if somebody can't do their past work, but we're still going to hold them to the standard of, is there other work they can do? But if the cards are already kind of stacked against them just on their age alone, how much worse are they going to be stacked against them if they've got medical problems and impairments on top of their age gap? So Social Security created this special set of rules that takes into account your education, your past relevant work, your history of skilled or semi-skilled work, if you have any, transferability of skills from semi-skilled or skilled work, if you have any, your ability or inability to do skilled or semi-skilled work, and finally, your maximum residual functional capacity, or RFC, another concept I've talked about in prior videos, and I'm going to hit it a little bit more detail on this one. All right, so let me start with one of the factors they take into account. And when I do an intake on a new potential client that's referred to me, among the questions I ask, this is usually the second question. The first question I ask is how old are they? Because that's going to tell me immediately whether there's going to be potential to trigger these grid rules. And then the next thing, that's all kind of part of it, just the same, is what's their highest level of education? Because education matters for these rules, which you'll see as I get into this further. So Social Security typically classifies education in terms of whether you did or did not graduate high school. If you graduated high school or go higher, any level of college, whether you graduate college or not, get a degree, get multiple degrees, advanced degrees, etc. Generally, you're in the same age category for their purposes and for the purposes of these grid rules. There's no separate categories of high school, college graduate, professional degree, graduate degree. Basically, it's high school plus. But the thing to keep in mind, and you'll understand as we go through this more, the more educated you are, the more likely it is that you've done skilled work and you may have transferable skills, which again will be relevant as you'll see when we get into this. Now, for less than high school education, meaning you did not graduate high school or get a GED, if you didn't graduate but you did obtain a GED, then you will be considered a high school graduate and be up in this higher category. But if you're not, then you break down into one of three subcategories. First one is illiteracy. Illiteracy means, and these definitions, by the way, are directly from the Social Security rules and regulations. I didn't cite them here, but that's where they come from. Means the inability to read or write. We consider someone illiterate if the person cannot read or write a simple message such as instructions or inventory lists, even though the person can sign his or her name. Generally, an illiterate person has had little or no formal schooling. Now, frequently, the people that are going to potentially fit this category are people that usually come from another country. They might be technically U.S. citizens, but they may not really speak English. And by the way, this pretty much implies the ability to read or write English, but the rules are also being updated to say that if you can read it in your native language and there's an ability for it to be translated, then it might still count the same. They used to consider somebody that couldn't speak or write English in that same category, but the rules are changing a little bit. Then there's marginal education. Marginal education means the ability in reasoning, arithmetic, and language skills which are needed to do simple, unskilled types of jobs. Generally consider formal schooling at a 6th grade level or less as a marginal education. So somebody went through some schooling but didn't quite get all the way. Lastly, We have limited education. That's pretty much as high as you can go without actually graduating or getting a GED. Limited education means ability in reasoning, arithmetic, and language skills, but not enough to allow a person with these educational qualifications to do most of the more complex job duties needed in semi-skilled or skilled jobs. We generally consider 7th through 11th is a formal education in a school is limited education. So that's the breakdown on education. All right, now, as I referenced before, let me give you a little refresher and a little more detail on the concept of residual functional capacity, or RFC for short. Okay, love my little animations. All right, RFC, which is defined at this code section, 20 CFR 416.945. Your impairment and any related symptoms, such as pain, may cause physical and mental limitations that affect what you can do in a work setting. Your residual functional capacity is the most you can still do despite your limitations. We will assess your residual functional capacity based on all the relevant evidence in your case record. Now, typically, it's the medical evidence that's going to be largely what determines that, but also there can be just as much non-medical type evidence. If you have prior schooling records that show that you had difficulties in school, whether it's a mental or cognitive or learning abilities, you can reference that. Sometimes you have third-party statements that can reference these types of limitations, and so on and so forth. Now, RSC is expressed in terms of both physical capacity and mental capabilities. The physical scale has 5 levels, and this is something you've probably heard me reference in prior videos. So the lowest level is sedentary, then light, medium, heavy, and very heavy. And I will explain those in more detail in the coming slide. Mental breaks down to various abilities that determine whether you can do skilled or semi-skilled work or just unskilled work, if at all. All right, let's continue with that a little bit more. So on the physical scale, for the purposes of these grid rules, you're going to understand soon enough, the only relevant physical scale RFC levels that we're concerned with are sedentary and light, and in a very, very limited circumstance, medium. You'll understand on that as well going forward. But typically, sedentary and light are the ones that are going to give us an easier time to utilize these rules to your advantage. So let's start with sedentary. Again, that's the lowest physical demand level they recognize. Sedentary involves sitting 6 hours of an 8-hour workday, standing and walking no more than 2 hours of an 8-hour workday, and lifting and carrying no more than 10 pounds on occasion. Now, there can be other limitations that are included that will render somebody only capable of doing sedentary, but typically those are the 2 main things you need to see. Light, which is the next lowest level, is standing and walking up to 6 hours of an 8-hour workday and lifting and carrying up to 20 pounds on occasion. Now, the key with this one, this is where it can get a little dicey, because sometimes you can see someone that's given an RFC where they can't stand and walk up to 6 hours. Like, for example, you might see somebody that can only stand and walk up to 4 hours of an 8-hour day, and you might think to yourself, well, then that's not light, that's sedentary. It could be, it's very possible, but because the definition actually gives more of a range rather than a specific limit like sedentary does, then it is possible to say that somebody that can only stand and walk 4 hours, because it's up to 6 hours, not exactly 6 hours, that could still be considered either light or maybe some hybrid between sedentary and light, which doesn't technically exist, but for classification purposes, they can kind of make it exist if they want to. But the bigger ticket item here that typically puts it over the edge into light or something that resembles light is the lifting and carrying requirements, because 20 pounds on occasion, and I didn't include this on the slide, but I will tell you all, occasionally is officially defined as up to 1/3 of the 8-hour workday, which is roughly mathematically like 2.5, a little over 2.5 hours a day. So if you're spending that much time in an 8-hour workday lifting and carrying up to 20 pounds on occasion, a job is typically going to be considered light. And if you're capable of doing that, then that's typically going to be considered your RFC. So it is important to understand the difference, because when you see and understand on the coming slides how these grid rules work, being in a clear RFC category can be the difference between an automatic approval versus not. Medium, again, for the limited circumstance it could apply, and I'll get into that, is the same as light, but lifting and carrying up to 50 pounds on occasion. So the difference between light and medium is strictly based on the weight and carrying requirements. There are also, again, other limitations that could dictate whether something is light versus medium, in terms of doing postural movements like bending, stooping, kneeling, crouching, crawling, reaching, balance, climbing ramps and stairs, climbing ladders, ropes, and scaffolds. There could also be components of using foot controls to operate, whether it's driving a vehicle, whether it's operating like a forklift, let's say, or stuff like that. So yeah, there's a lot of different ways that can go as well. But that's the basic breakdown. If you're higher than medium, the grid rules are not going to be triggered. So you don't even have to worry about that being an issue. And quite frankly, if you're capable of doing higher than medium level physical demand, then typically not only you're not going to be likely to be approved for disability, you're not likely to be able to be in a position to even be applying for it, because you're probably not even going to be out of work. Okay, now let's turn to the mental scale from the physical scale. So there are various factors, again, that determines a person's ability or inability to perform skilled or semi-skilled work. And these include, but are not limited to, little lawyer language I slipped in there, your ability to understand, remember, perform, and carry out simple and routine versus complex tasks and instructions. I did not include the official definitions of these, but they are in those same sections of the Code of Federal Regulations. Your ability to maintain attention and concentration for 2-hour segments and to do production rate or pace work. So like, for example, if you were working with a strict quota type of job where you had to get a certain amount done within a certain period of time, or like if you were working on an assembly line and you have to make sure a certain amount's getting through per hour, per whatever segment of time, that's what's going to determine what your limitation, if any, is in this section. And I've mentioned this at least a little bit in passing in prior videos. The idea about limitations on attention and concentration, sometimes that by itself can be a determining factor. If you've got impairments that clearly limit your ability to maintain attention and concentration for any significant period of time, let alone 2-hour segments, which is when you typically be afforded at least one 10 to 15-minute break in a workday, they're going to be really hard pressed to find work that some employer would be willing to take you on to do, because you're not going to be productive enough. And likewise, you probably won't be capable of working and meet the criteria for disability. So this is just one in passing. I'll say that when you have these types of limitations from physical or mental impairments or both, and you can really amp up the documentation to prove it and get doctor or medical provider support from family members or friends that have seen it, any and every one of those things, believe me, makes a huge difference. Then also your ability to interact with the general public, coworkers, and supervisors, because the less you're able to do those things, the more likely it is that you're not going to be able to do work in the skilled or semi-skilled levels, because it is really going to be difficult to not have the ability to regularly interact with different people you may have to in those types of jobs. Now let's talk a little bit also, because again, this is all going to come together really, really nicely in just probably a slide or two, but let's talk about transferability of skills. So first of all, the Program Operations Manual System, POMS for short, that is another set of rules that Social Security operates under. It all kind of branches from those Code of Federal Regulations. But Section DI, which stands for disability insurance, you know, it comes under those rules. And then this is the section number. This is their official definition of what constitutes a skill, because sometimes there actually is controversy in the world of Social Security about what technically constitutes a skill from work, if you're doing skilled or semi-skilled work in the first place. If the work you're doing isn't even classified as skilled or semi-skilled, then it's a non-issue. But a skill is practical and familiar knowledge of the principles and processes of an art, science, or trade, combined with the ability to apply them in practice in a proper and approved manner. This includes activities like making precise measurements, reading blueprints, and setting up and operating complex machinery. I mean, these are just random specific examples, but should give you a little bit of an idea. A skill is knowledge of a work activity which requires the exercise of significant judgment that goes beyond carrying out simple job duties. A skill corresponds directly with a work-related task that generally requires more than 30 days to learn. So a lot of times what can also classify whether work that you've done is skilled or semi-skilled work is the typical amount of time it takes to learn how to do that job when you first get the job and you go through some kind of training or probation period. So if you learn it in 30 days or less, then it's generally not going to be skilled work with any transferable skills. Now, this is an important concept too, vocational adjustment. Vocational adjustment means, and this is where it relates to transferability of skills, means learning about tools, work processes, work setting, and industry that a specific individual would need to do to perform work in another specific occupation. So, let's see, I gave myself a little typo there. I think that's supposed to say generally the older you are, the more minimal adjustment has to be from one specific occupation to another in order for the skill to be considered transferable and avoid these grid rules. So transferable skills can actually be a grid rule killer. So that's why it's important to be aware of and understand the work you've done in the past that constitutes past relevant work, and to be able to pinpoint what you did or didn't do in that work and not trying to make it seem like it was something that it wasn't, so that they can't try to find a way to say, this is skilled work and here's transferable skills from that work that can actually be utilized in another specific occupation. So again, the main thing that would determine whether you've got a transferable skill is how minimal, if any, the adjustment is, the vocational adjustment from one specific occupation where you were doing that work and employing those skills to another one. Now, and the definitions, by the way, for tools, work processes, work setting, et cetera, are in this same section of this POMS section here. So just be aware of that. All right. So now you've got the firm background and basis to understand what we're talking about. Now let's put the grids to work and let's bring it all together. How do we align the grid, the rows and the columns, which I'm going to be actually showing you them before we're done here. So the first thing we have to do is start with the actual age category. So there's different grids of rows and columns that correspond with your actual age category. So first we have to know what the age categories are. Now, for the purpose of the grid rules and when they can actually apply to determine someone is disabled, there's four main ones that we focus on, because if you're not in one of these, then generally these grid rules aren't really going to help you at all. So the first one is closely approaching advanced age, which is defined as anything 55 and up. Just realizing another typo there. That's supposed to say advanced age, the first one, 55 and up. Second one is closely approaching advanced age, which is 50 to 54. Younger individual, specifically 45 to 49. Now, I tell clients all the time, if you're under age 50, you're considered a younger individual, which is true. But there are actually technically two categories of that. There's 45 to 49 and then 18 to 44. So if you're in the 18 to 44 category, that's typically where you're not going to come into play with these. But if you're in the 45 to 49, you possibly could. And then finally, there's a special age category, and I left it separate because you'll understand when I get to it. Closely approaching retirement age, which is 60 plus. Now, without getting into too much of a tangent here, for those of you who aren't aware, when you reach age 62, you're eligible for early retirement benefits. And I will be doing a future video, I know for a fact, on this topic about the interplay between early retirement when you're that old and disability, if you're eligible for potentially both. But 60 is still not quite there, but it's pretty darn close to it. And they know you're pretty much you're clearly on the back nine by that point. So looking for a new career and a fresh start at age 60 plus is not typically in the cards for most people. I'm not discouraging anybody. I know there are inspirational, awe-inspiring stories out there of people completely starting over. I remember when I was in law school, I had a guy who clearly had to be in his 70s, possibly even early 80s, in my class that was going back to learn. And I don't know what he was planning to do with it, but I commended him and tipped my hat to him tremendously. So now that you know all that, 3 factors to align these grids once you're in the right one for the age category you're in. 1, can you perform past relevant work, or do you have any past relevant work? Now, I'm coming back to that breaking news reminder. Again, now that we know past relevant work come June 8th will only constitute work you've done in the last 5 years. Now, and also just to clarify, I won't go into too much of a discussion, We're not specifically necessarily talking about 5 years from the current date. Often we are, but there are circumstances where we could be talking about 5 years prior to the date that you allege you became disabled and stopped working, or we could be talking about 5 years prior to your date last insured under Title II SSDI. It's certainly an assessment that I or any attorney representing you could make, but again, it is going to be still very much a game changer in my book. Now, the other thing to remember about this, just as a quick sidebar, past relevant work is, again, step 4 of the 5-step sequential evaluation process. And you have to prove this anyway, or your claim will be denied. So it's part of these grid rules, but it's also part of the normal evaluation process. If you can't prove that you're not capable of performing your past relevant work and Social Security thinks you can, your claim is going to get denied there anyway at step 4, regardless of whether these grids could otherwise apply. So that's why they built it into it as well. So that's the first factor to align it. The second one is whether or not you have any transferable skills from your past relevant work, if it was in fact skilled or semi-skilled work to begin with, or if you can even currently do skilled or semi-skilled work. So even if you have a history of skilled or semi-skilled work, if you can't do that anymore, if you can't do work at that level, then it doesn't matter if you have transferable skills. Now, also, I didn't write it in here, but just sort of built into this as well, your education level, when you see these grids, you'll understand factors in also. So we'll get to that as part of the whole transferable skills factor as well. And then third and finally, what is your maximum physical RFC? Now, the transferable skills and the whole discussion about skilled and semi-skilled work, that all derives from the mental scale of RFC. But then once you've gotten through all that, now we're focused strictly on the physical RFC scale. So let's keep grinding those grids. Let's actually put it in motion here. So when the first two factors align, meaning you meet, first of all, you meet the education level, or your rule that dictates what your education level is. You meet the factors of A, not being able to do your past relevant work, and B, not being able to do skilled or semi-skilled work, not having a history of skilled or semi-skilled work, or not having any transferable skills. Any of those by themselves or in combination would do it. The question simply becomes, what physical RFC is needed? And I'll tell you all, in all the years I've been doing this work, this is typically the part where we butt heads with Social Security the most, because they know how these rules operate the same as we do. So they also know what it's going to take to try to avoid the rules. And granted, they will get very creative oftentimes and try to claim that, you know, they've been very generous in the RFC they assign, and yet in spite of that, the past relevant work is work that can be done, or that there's transferable skills from that work. So they can easily deny it on that basis alone. But the vast majority of times, if you ask any attorney out there, this is the part that we're usually fighting an uphill battle on the most, because we're arguing the RFC that we know our client needs in their age category and with the other factors to prove disability, whereas Social Security is going to argue the opposite, and usually kind of as a way of getting you just close enough, but not quite over the edge. That's what they're going to do. So I'll give you an analogy for that in a second, but let me go through the ones you actually need for the different age categories. So generally for advanced age, again, 55 and up, you need to show you can do light or lower. So light or sedentary, basically. And these numbers here, which you're going to see when I show you the actual grid rules, these are actually the numbers that correspond to the specific rule that aligns the rows and columns that we're talking about. So 201 versus 202 here, that number denotes which physical RFC level we're at. The 201 category is all sedentary. 202 is all light, and you'll see shortly 203 is where we get into medium. So these are, I listed all 8 of the specific grid rules for the advanced age category that if you meet the criteria in them, will all dictate a finding of disabled. It is required by law. Generally, for the closely approaching advanced age category, 50 to 54, you have to prove sedentary work. You can't be capable of doing higher than sedentary. And these are the rules within that category. 20109, 10, 12, and 14. For younger individuals, 45 to 49, if they are illiterate, as I defined it earlier, and they have no past relevant work or unskilled past relevant work, and they can do no more than sedentary, then they will be disabled under this 201.17. Lastly, for closely approaching advanced age, or retirement age, excuse me, 60 plus, if they are illiterate, have marginal or limited education, and no or unskilled past relevant work, and they can do no more than the medium RFC level, they will also be considered disabled. So more frequently than not, this one would typically come up with somebody that's truly never worked. I mean, it is kind of a rare thing, but it can happen. It's not impossible that somebody literally never worked a day in their life, whether it's because of medical reasons, maybe it's because when they were younger and more able-bodied and healthy, they were doing other things, housewife, house husband, whatever the circumstance, taking care of a sick family member. Anybody's guess. But the point is, that would be the typical circumstance where you get someone that old that's trying to go for disability because now they physically couldn't work even if they tried, and yet they have no, again, or unskilled past relevant work, and they can't do more than medium RFC, which, to be very honest, when you get up there in years, to think about the idea of possibly being able to do higher than medium, which is really heavy weightlifting, typically 100 pounds or more at a time, that's kind of hard to fathom for somebody that age, no matter how good a shape they're in. So unless you're a professional bodybuilder or something. So that's typically what you're looking at. Now, coming back to what I was referencing before. So you look at, I would say, focus on the first two bullet points here. So when we're in the advanced age category and we know that all the other factors align, we know all we have to show is that our client can't do higher than the light exertional level. So what is Social Security typically going to do? They're typically going to try to go out of their way to find somehow, some way of saying, in spite of any medical evidence to the contrary, that the person can do at the medium exertion level, because they know that's going to be just close enough, but not quite there to put you over the edge. When you're in the closely approaching advanced age category and you need to show sedentary, they're going to find light. And they're even going to go a little extra mile. They're going to make it look like they're doing you a favor. They're not even going to do a full range of light work. They're going to say, well, you can do light work, but you've got some other limitations. You can't stand more than 4 hours in a day. Sometimes they might even say you can't stand or walk more than 2 hours in a day, but you can still occasionally lift 20 pounds. You can still occasionally do this, that, or the other. So that's going to be enough to avoid these grid rules. And again, they know exactly what they're doing. The analogy I always give people on this one, at least the one that always comes to my mind, if you ever play those lottery scratch-offs, I know every state has them, and I'm sure the concept of them is pretty much universal. Let's say you have one where you have to match 3 amounts of money to win that amount of money. So let's say you scratch off on your card, and the high prize is $20,000. You scratch off one 20,000, you scratch off a second 20,000, and you're getting super excited because you think, oh my God, I need one more 20,000. I just won $20,000. So you start scratching the next one, and you see a 2, and then you see a 0, and you're like, your heart starts beating out of your chest. Then you see the decimal point, and it's $20. You go to scratch the next one. You see a 2, you see a 0, you see another 0, get excited again, another decimal point, $200, and so on. So you'll see like 2 or 3 that look just like that, and you get so out of your mind, panic-stricken that, oh my God, I'm about to become $20,000 richer, only to realize 3 or 4 of them were strategically placed to make it look like you were going to win and get you just close enough, but not quite there. That's oftentimes how I see these grid rules operate. And that's why developing pinpoint evidence is so vital in this circumstance. Well, let's take a trip, shall we, to the grids. And I'm going to come back to my slideshow. So I'm going to stop this share and I'm going to start a new one now. So let's get to that. Should be, here it is. All right. Now, this again is the website that I gave you the address to in the earlier slide, and you can do a quick Google search to say Medical-Vocational Guidelines. This will come right up. This will be the first one that you see. So this, you can see it's right on the Social Security website, so it's not some random third-party website. So here's some information and definitions. We don't need to go through all that because that's largely what my PowerPoint just summarized for you. So you can see here, for one thing, here's what I told you. The 201 section is for sedentary, 202 is for light, 203 is for medium, and 204, which doesn't direct disabled for anybody, is the heavy or very heavy category. So we're going to scroll down so I can show you what the first grid looks like. So here we go, table number 1. So here you see, like I promised you, this is your grid. So you've got the columns here to align and the rows here to align. So first, you're looking for your age. So let's say we've got somebody who's 55. Now let's jump up a smidge, shall we? So let's say we've got somebody that is a high school graduate. Now, the whole concept here that, and this is one, candidly, in all the years I've done this, I've never really understood what difference this necessarily makes, but it's still there. So they differentiate high school graduate or more does not provide for direct entry into skilled work versus provides for direct entry into skilled work. Now, I, to this day, have yet to come across a client who, when they graduated high school, went directly into some kind of skilled work. I mean, typically, you're either going to college or you're going out into the working world to learn something that might develop into skilled work, but you're not starting there necessarily. So, generally speaking, we're not usually going to be involved with this middle section. So let's say we've got somebody who's 55 and up in advanced age. They have a high school education, but did not go directly into skilled work. And their prior work experience is either unskilled or they have none. And again, this category is clearly sedentary. We know they've already met the sedentary, or at least we're asserting that they're sedentary. There's the decision right there. You can see it in black and white, disabled. That cannot be ignored by Social Security. They cannot find a loophole or a reason around it. If they've made the findings of fact to say this person, I mean, age speaks for itself, education speaks for itself, work history speaks for itself. But if they clearly meet the sedentary requirements, they're going to be found disabled. Same thing here with 201.06, high school graduate that does have a history of skilled or semi-skilled work, but the skills are not transferable. Or again, even though it's not written here, they can't do skilled or semi-skilled work anymore, and that's been confirmed. Once again, disabled. We scroll down a little further. Here's where we start differentiating. Here's the closely approaching advanced age category. So again, we've got limited or less for the education, or we've got high school graduate here for the education. And again, unskilled or none, or skilled or semi-skilled, but skills not transferable, disabled, disabled. Now I'll scroll down a little further. Let's go to this table. This is the 202 table for light exertion level. Now, in this, I'm sorry, actually, before I do that, let me scroll back up because I did want to reference, I referenced this earlier. So here in the sedentary category of the 201s, here's rule 201.17. So again, younger individual age 45 to 49, if they are illiterate, as that's defined, and they can do no more, or they have unskilled or no past relevant work, they will be found disabled. But you can see here, that's the only one. Everyone below that is not disabled. And this DO period basically is like the quotation marks under to say same thing. So if you're reading this and you didn't know what that meant, that's what that means. All right, now going down to the light table. So again, for the most part, the only time the light category is going to trigger is if you've got an advanced age individual. So you can see the rules. I've referenced them again. 202.01 disabled, 202.02 disabled, 202.04, 202.06. Now, when you cross over into the closely approaching advanced age category, the only one that's going to trigger disabled for a closely approaching advanced age individual that can only do light, or that can do up to light exertion, they have to both be illiterate and they have to have an unskilled or no past relevant work history. That's the only way you're going to trigger that. So otherwise, if you're in the 50 to 54 category but can do light and any of these apply, you will not automatically be found disabled. And then finally, scrolling down one more time to the medium table, 203.01 and 203.02. The only time you're going to be able to prove disability is if you have an individual closely approaching retirement age that either has marginal or education, or is illiterate, or has limited or less education. But then there are some specifications on their past work history. So for marginal or illiterate, they can either have an unskilled work history or no work history and be found disabled. If they have limited or less, they have to have no past relevant work history in order to be found disabled. And then the only other one that can possibly trigger after that is in the advanced age category right here, Rule 203.10. So again, with this one, they've got to have limited or less education, and they've got to have no past relevant work whatsoever. And then they will be considered disabled under that rule. After that, as you can see, I'm just doing a quick scroll down. 204 doesn't even have a table because, again, if you can do work at that level, you're not going to be disabled. It's just that simple. So that's the wonderful world of the grids. Now you can see them, you see what I have to consult. I mean, most of these I know pretty well off the top of my head from many years of doing this, but occasionally I do have to go back in and reference some little nuanced portion of the rules. So let's go back one more time, one final share with my PowerPoint. Let's get back to that. So we took our trip to the grids. Hope you enjoyed that. Now, I have one final important consideration for you. If you are in an age category that can potentially trigger these grids, you want to, from the get-go, start developing your medical and non-medical evidence to prove what you need to. Medical records, this includes medical records to show your maximum RFC and trying to get assistance and support from your doctors or medical providers, medical source statements, which we've talked about, and I'll probably do a future video on as well. Detailed information on your work history report form, which again, I haven't referenced before, but I will probably do one on that in the future as well. Basically to show what you did and didn't do in the job so they classify it correctly for past relevant work determination and transferable skill determination purposes, and so on and so forth. Told you one final important consideration, and I saved this one purposely for last. If you do not satisfy a grid that leads to a finding of disabled, like I showed you in the grid, it's okay. I don't want you to be discouraged or despair if that's the case. That doesn't mean you can't or won't win your claim. There are many other factors that determine disability. This just happens to be one of the easier factors to do so. This happens to be one of the most simple ways to be found disabled. At least it should be. Again, I think Social Security does go out of their way a bit to make it more complicated. But at the end of the day, when it comes down to it, if you can satisfy these grid rules, you're going to have a much wider and easier path to disability. But if you can't, that doesn't mean that you can't be found disabled. It just means you won't be able to do it down that path. You have to go down a different path. You have to show, again, you've got significant attention and concentration and focus limitations, or you're going to be frequently absent from a job or have to take excessive numbers of breaks because of your conditions, and so on and so forth. And as always, if any of you have any questions, again, phone and email are the best ways to contact me. I respond directly to phone calls, emails, and again, texts. So never hesitate to do that. And with all that, I wish all of you a very, very happy Star Wars Day. May the 4th be with you. I hope you have enjoyed this little trip into the grids. And I do hope that I'll be seeing you for my future videos, and I'll be excited to share my experience at the National Conference in Nashville this week when I do my next one. Thank you very much, and I bid you all a fond farewell.